Good evening all. We are happy to welcome you all here. Today we discuss about patenting of Siddha drugs. First, I would like to welcome our guest, Ms. Prem Rajakumari. She is an intellectual property lawyer having vast experience. She providing legal consultancy service on various matters. Intellectual property rights including trademark, patents, copyrights, and commercial matters. She has advised business startups, trademark applications, and patent registrations at the national and international levels. She had work experience in High Court of Madras, Center for International Trade and Economic Laws. She presented the paper on international trade laws and treaty interpretation on November 2020, BRICS and economics development on December 2020, competition laws and issues in cross-border transaction on December 2020. She is also the member of CBSC Groups of Legal Studies. On March 2019, she has awarded the Crown Lady of Women. Once again, I welcome you, ma'am. We are extremely hopeful that this section is also going to be great for Siddha system. Welcome all.
Good evening, everyone. Good evening, everyone, and thank you for the brief intro. I have some presentation to share with you. I hope I can share my screen and we can go ahead with the topic. I hope you're able to view my screen.
Yes, ma'am, it's visible.
Yes, yeah. So very good evening. So the topic for today's presentation is patenting Siddha drugs. Now, firstly, I would like to cover what are the basics of granting a patent or getting a patent, subsequent to which we will go in detail on how to get a patent, how to draft a patent application, and so on. And followed by, you can also ask questions in between, or if you feel like asking questions at the end of the session also, you are welcome. Now, firstly, what is a patent? A patent is a right granted to the inventor for a particular period of time. Now, say a person has made a new invention, he gets an exclusive right of licensing it, using it, or remodeling it for a period of 20 years according to the Indian Patents Act. Now, say there are some inventions which are already in existence and a person would like to make a modification or an alteration of it, subject to an inventive step being involved. So that product is also patentable. Now, the types of patent. So there are two types basically. One is a process patent and the other one is a product patent. A process patent is one for which the particular process itself is being patented. And a product patent is one in which the outcome of the process is being patented. Now, the criteria for grant of patent by the Indian Patent Office. There are 4 criteria which the Indian Patent Office will basically look into. One is it should be novel. Second one is it should not be very obvious. So non-obviousness is very important. Third one is there should be an innovation of a product or a process, and it should also involve an inventive step. The last one is it should be used. So it should be capable of industrial application. Now, what is novelty? Novelty is that which is not publicly available. So anything which is new is called novel. I've also quoted certain provisions of the Indian Patent Act, but if you want, you can take a note of it. I'm not going in depth because I feel the audience is mostly technical. The next one is inventiveness. So inventiveness is something which involves innovation and it should not be obvious. So non-obviousness is an important criteria. As I said, process patents. So the manner of manufacture. Now say there is a drug or a new medicine that you are inventing. So the particular process itself can be patented, provided the process should be new and something should be added. It is not that just an addition of an ingredient can be patented. The next one is usefulness or the utility of the invention. This applies to both process as well as the product patent. Now, once a product is being invented, how far it is useful, or whether it is useful for industries or individuals or public health, etc. Everything is covered under the caption of usefulness or utility. And it is very important that the utility should be clearly mentioned while making a patent application. Now, there are certain restrictions on patentability. Now, certain provisions of the Indian Patent Act, which is section 3 to 5, it speaks about, or it portrays on the restrictions regarding patentability. Now, for example, innovations which are related to atomic energy, which falls under the Atomic Act, and it is not patentable. There is a provision in the Indian Patents Act, which is section 3, and it broadly speaks about inventions that are not patentable. Now, these are the following inventions which are not patentable. Now, an invention which is frivolous or which claims anything obviously contrary to well-established natural laws. So anything which is contrary to the national laws available in India is not patentable. I am just covering only the topics which are related to your subject so that we can leave out the rest of the ones. Now, an invention or the primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health or to the environment. So any invention which is contradicting to the natural environment or public health or morality of the laws of India are not patentable. The mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. So as I said, any discovery, so which does not involve any innovative step or inventive step, cannot be patentable. So it is just a discovery of a substance and that cannot be patentable. The mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use for a known substance, or the mere use of a known process, machine, or apparatus, unless such known process results in a new product or employs at least one new reactant. So just a discovery which does not involve any innovative step, if you have only added one ingredient, as I said before, it is not patentable, because that will be hit under the concept of obviousness. A substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof, or a process for producing that substance. Now, if there is already a product existing and there is only an addition of a component to it, then that addition, the process itself is not patentable and the product also is not patentable. The mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. So just an arrangement of something, when there is already there and it is just an arrangement, so that is also not patentable. A method of agriculture or horticulture. So agriculture methods are all not patentable. any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. So here, if there is a process that is related to medicine or surgery or diagnostic or therapeutic or other treatment for human beings or animal health, is not patentable. Sorry. Plants and animals in whole or any part thereof other than microorganisms, but including seeds, varieties, and species, and essentially biological processes for production of propagation of plants and animals. So which is already there, existing in nature. So all these are not patentable. Now this has got a lot of exemptions, which I will also be covering during the lecture. A mathematical or business method or a computer program, per se algorithms. So this is also not patentable. A literary, dramatic, musical, or artistic work, or any other aesthetic creation whatsoever, including cinematographic works and television productions. So this will be covered under copyright and it is not patentable. A mere scheme or rule or method of performing mental act or method of playing game. So this is also not patentable. A presentation of information. So any presentation which is only informatic, so that is not patentable. Topography of integrated circuits. So again, this is all covered under physics and this is not patentable. An invention which in effect is traditional knowledge or which is an aggregation or duplication. So yeah, I would like to give an example of Tulasi Telam. So Tulasi Telam is already there and it is also available for centuries. So that is not patentable. But if there is an addition or whereby the use of Tulasi Telam is extended for curing some other disease, then it can be patented. What are the essentials of a patent? Now, a patent should have a detailed view of the invention. Now, this is very important as it is helpful in determining the essentiality of the patent of the product. Now, this patent also protects the interest of the inventor. Now, there are two kinds of patent. One is a provisional patent and the other one is a complete patent. Now, for example, you are making a process or a product. Now, that is not complete, but you would like to file an application. So straight away, you can go ahead and file a provisional patent application. Now, this provisional patent application is valid for a period of about 12 months. Now, this 12-month period is available for you to complete your research and complete the complete product or the process, so that at the end of the provisional application or the end of the expiry of the provisional application, you can file a specific complete specification giving the complete details of the product. So you will also be covered even before your complete product or the complete process is available with you. Now, what is the procedure for obtaining a patent? Sorry. I think I went somewhere. Yeah. Now, before an application is submitted, a patent search should be performed. Now, this patent search is performed and analyzed, wherein all the applications relating to the particular invention is being sought from the patent office. Now, after we get the search report, we analyze it, subsequent to which an application is being submitted. Now, once the application is submitted, the next step is the registry will go forward for examination of the application. Now, if the registry has got any queries or objections, they would be posting the queries or objections, subsequent to which we should be giving answers or replies to the Indian Patent Office, so that it will go ahead for advertisement. Now, once this advertisement of the patent application is being done, then there would be a process called opposition. Now, in opposition, if there is as I said, just like examination, if there is an objection to the grant of the patent, now that objection will be raised during opposition. Now, for opposition, hearings would be given by the registrar. Subsequent to the hearings and the answers provided by us during the show cause hearings, the grant and sealing of a patent will be done. Now, I'm also briefly touching upon what are all required for getting a patent, so that you can keep in mind at the time of making a patent application. So a patent should broadly cover the title. The title should be as broad as possible, so that there is no duplication of a patent application by another person. Now, the opening description of a patent is very important, because it should touch in a nutshell as to what is the invention or the patent about. Prior art description. What are all the prior arts that is already available with respect to the subject, and what is the next innovative step that you have made in the application should be clearly demarcated and written in the application. Now, what is the object and statement of the particular invention, be it product or process, should be clearly specified. Now, a detailed description, if it is a process patent, what are all the processes that are being followed, what are all the ingredients that are being added, and in what quantity, what is the new innovative process that you have updated with respect to the innovation, and what is the outcome. Everything should be given in detail with the particular quantities also. And what is the claim that you're making is the last one that should be mentioned in a patent application. As I said, the title should be as broad as possible, so that your title itself should contain a series of all the matters that are related to the particular industry. But it should be as concise as possible. So a concise statement providing the crux of the invention. Now, the entire scenario of the invention should be given in the title itself, so that whenever a search is being made with respect to a particular invention, it is only the title that is being captured. So the title should be as broad as possible. For example, a process, product, and apparatus applied for, the title should accommodate all of this. If you're applying for a process patent, a product patent, and the complete scenario of the entire process and the product should be covered in the title itself. The opening description or the preamble of the invention. Now, the background of what the issue is, what is the summary that you're providing, the usefulness of the invention, everything should be in detail, so that a person who does not have any technical knowledge or specific knowledge with respect to the particular subject, so if any person goes through the patent application, he should be able to understand what the invention is about. Prior art references. A brief write-up of what is already available should be discussed, or it should be already mentioned in your application. If there is an update of the prior art reference, or if there is a working on the prior art reference. Now, say for example, as I said about the Tulsi Telam issue, the Tulsi Telam is already there, and you want to make anything new or additional to this Tulsi Telam, but involving various other steps. Now, this Tulsi Telam is a prior art reference. So this should be clearly mentioned in the application. As I said, it increases the credibility of the invention. Now, rather the patent examiner should not get confused that this is already available and for centuries, and what is that you're claiming? So the prior art reference should be clearly demarcated so that it increases the credibility of the invention. Now, they should also distinguish as to what is known and what is not known. So this Tulsi Telam is already known. We should have a demarcation of what is already known to everybody and what is the new one that is being pitched to everybody through the patent application. Now, what is the object of a patent application? Now, the intention or purpose of the invention should be clearly described in the application. Now, it should demark the main or essential objects and the ancillary objects. Now, you might have certain main objects as a cure of certain diseases. So that should be your main object of the invention. And it may also cure certain other diseases. So that can be your ancillary objects. So there should be a clear demarcation of the main objects and the ancillary objects. Now, a statement as such is optional, but it just improves the, it is just an addition to the patent application. A detailed description of a patent is very essential. Now, your invention should be mentioned very clearly, stepwise, so that a person, a layman, if he reads also, should get the particular, should be able to understand. So anybody with just the application should be able to follow the steps and make your product or the process. So that is very important when you're filing a patent application. Now, a detailed description. So these are the conditions for a detailed description. The description must be sufficient without making further inventions, and the description must be fair and not unnecessarily be difficult to follow. So any person who's just got the patent application should be able to make it without your assistance. So that is very important. Now, what are all the patentable aspects of the invention? So first is, as we already discussed all of this, novelty, inventiveness, utility or usefulness, the manner of manufacture, and the patentability according to the laws of India. So manner of manufacture is the process of manufacturing a particular drug. So that process itself can be patented provided there is an innovation in the process. Now, some important points to just consider. Now, you should have a complete idea of what your product or your process is about before making the patent application. Now, for a provisional application also, you should have sufficient idea or sufficient knowledge of for what your patent is being filed. Now, you should envision it before drafting, and if the invention fails to produce any promised result, then the patent becomes invalid. So the invention should always be capable of giving out the result that you're aiming at. Now, this is just a small case study so that it will be easier for you to draft or have an idea of before making a patent application. though this is related to Ayurvedic formulation, you can also take it as a reference for Siddha formulations. A process of preparing plant-based Ayurvedic formulation for the treatment of Parkinson's disease. Now, this process, an application has been made for this particular process. Now, it should contain the background of the invention. So, what this invention is about, and there is no specific and proven Ayurvedic medicine for this particular disease should be clearly established. And what are all the medicines that are available currently, though it is in allopathy, and what are all the side effects that have been caused should also be mentioned in the application. The objectives of the invention, the main object as well as the ancillary objects. So the main object would be treatment with no side effects, and ancillary object would be how delicious the drug is, and how whether it is soluble, etc., can be your ancillary objects. The statement of the invention should be clearly established. The statement will be, say for example, a select ingredient from plant, which is Mucuna pruriens. So, and it is being pulverized into a fine powder. Then antioxidant is being mixed, stabilizer with powder. Now, all this should be clearly specified. A detailed description of the particular invention. Now, say an active ingredient, selective active ingredients, which is even though it is Mucuna pruriens, how it is being added to the particular process or the product should be very clearly defined, and what are all the steps that are being followed, which is whether it is pulverization or being dried or how it is being mixed. Everything should be very clearly mentioned in the application. Now, what is a claim? A claim is that for which you're applying for a patent is a claim. It should be broad, and what are all the steps or the processes that are being involved should be clearly mentioned, and what is the composition, what has been added, and what quantity, etc., should be clearly defined. Now, in Siddha formulations, what are all the challenges in Siddha formulations? So basically, most of the Siddha formulations are already existing in nature. So anything that you want to, so it is actually quite difficult for the patent office to grant a patent for basic Siddha formulations. However, if the Siddha formulation is able to convince the Indian Patent Office that this is being given for a particular disease for which there is no medicine at all, then there is a chance for getting a patent. Now, any new innovative step that is being followed in the making of the particular drug or the component, then it can be patented. So with this, I conclude. Any questions you can you feel free to ask. And I've also given my email ID. So if you want to file a patent application or anything related to patent, you can feel free to reach out to me. Any questions?
Thank you, ma'am. Thank you for the wonderful session. Just elaborate how to find out whether our ideas have already been patented or not, because we should not repeat.
Okay, so very basically, I would just say you can basically Google to find out. Once you are already having the particular invention, you can approach a professional patent agent so that a particular patent search can be done the database itself, and we will be getting you the what are all the
request Dr. Prem sir to share his insights.
Any other questions? I think I missed your last part. Can you repeat?
Is it audible now?
Yes, yes. A bit louder would be appreciated.
Dr. Prem sir to share his insights with you. Sir, over to you. Kindly unmute yourself, sir.
Yeah, good evening, everyone. Like today's session is an eye opener. Okay, thank you for the speaker, ma'am. Actually, I have few queries. Okay,
Please. Mm.
yeah, ma'am, is it mandate that we have to go always through the patent agent? Okay, or because there are lots of government of India facilitatory centers are there, who is directly connecting with the patent office or the wherever the science and technology unit where they are handling. So, is it always mandate to go through a patent agent? This is my first question.
Okay.
Uh, uh,
So,
okay, but first, once it is over, I will come up with the other questions.
all right, all right. So it is not mandatory that you should always go through a patent agent, but it is advisable to go through a patent agent because a patent agent has already got experience in handling or drafting a patent application or a patent specification. Because for a newcomer, though they might be very good with their invention or their be it a product or process, though they might have the exact technical knowledge, as a patent agent would be able to determine what is required and what is not required in a patent application, so that
Okay, but
the patent application does not get rejected. So that is why it is, though it is not mandatory, it is advisable to go through a patent agent.
okay, but actually here there is a what question? Like for example, if there is any opposition raised by any of the opposite party or any third person, because the answer mainly given by the inventor only. Because what happened is recently 2 or 3 of my colleagues who have applied for patent through a patent agent, like the material which was given by the inventor, like it was pursued by the patent agent in a different orientation, like uh, so
I
it was like, yeah, the opposition came and later, because they are all my colleagues also, so that is why the, because catching a proper patent agent also, it's important, like because if we are
Correct.
opening the Google, there are a number of, even in thousands and in 10,000, 20,000 people are there, like we filing IP, everything for low cost, like that, and all people are coming. So is there any standard site where they are giving the certification or authentication of the people who is really acting as a legal patent agent?
Okay, so I will, in fact, divide your question into two parts and answer it in two parts. So, firstly, for a reply to opposition, what you need to do is, after a reply is being drafted by your patent agent, you should always go through the reply, because you are the inventor of the particular product or the process. So you will be knowing it better than the patent agent. So whatever is very required, and for whatever reason the opposition is being raised, you should, though the patent agent has drafted, it is very important that the inventor reads it, and only after he is convinced, then tell the patent agent to go ahead with the filing. If there is any ambiguity or any misstatement given by the patent agent, is very, it is very important for you to curb it at the initial level itself. Otherwise, it will lead to several complications during the next stage of proceedings. Because once an application is submitted forever. So before submission only, you have the right to make changes. Now, if a patent agent is not entertaining the changes that you suggested, it is very important that you tell it to the patent agent and make necessary corrections. Now, regarding the details of the patent agent,
Hello.
Ma'am, your voice is not audible, ma'am.
now is it okay?
Yes, sir.
I hope you heard the answer for the last question, or you want me to repeat?
Repeat, ma'am. Repeat.
Okay. So, before making the filing, as in before giving a reply to the opposition raised by the patent agent, it is very important that you go through the reply before it is being submitted. Because once an application is submitted, it is submitted forever. You cannot make changes after it has been submitted. Am I audible?
We request
Yes, ma'am. You are audible, ma'am.
Okay. So it is very important that you read the reply before it is being submitted. So that is one part. The second part, can you hear me? Is it okay now? Can I go ahead?
Sorry for
Yes,
the
ma'am.
interruption.
There seems to be some disturbance in the line.
It is rectified now. You can
Oh,
go ahead.
okay. So if there are any discrepancies in the reply given by the patent agent, you have every right to rectify it. You should also advise the patent agent that this is not the suitable reply for the opposition raised by the registrar, because it is your invention and you would be knowing much more about it. So it is it is advisable and it is very mandatory also, I would say, before filing any reply, you go through the reply. Only after you're satisfied with the reply given by the patent agent, you should give a go ahead to the patent agent for filing the reply. That is one part. Second part is the details of the patent agent are already available in the site ipindia.gov.in, and we also provide patent application services. We also facilitate for filing patent applications, and the details of the patent agent are already available in the website. So any details with respect to the patent agent, you can get it from the website itself.
Okay, ma'am. Okay, ma'am. Thank you, ma'am.
Welcome. Any other questions?
I need request Dr. Sir to share his insight.
Dr.
Though
Satish
it is
Siddha.
because I shared the link late only. Venkatapan sir, please unmute yourself and come forward to share your insights or ask your doubts. So please.
Good evening, ma'am. Am I on?
Yes.
Ma'am, I have wondered. Our invention was already came as a newspaper article. Now, can we patent this?
Now this is a broad question, but on an outline I would just tell you, because I do not know what the invention is about, but still I would go ahead. So even though it is only a newspaper article, what is that you have contributed? Now say for example it is already available in the market and it is accessible also. What is that new thing that you have made? It should always pass the 3 tests. One is novelty, next one is non-obviousness, third one is inventive step, and fourth one is industrial application or usefulness. So all these 4 tests should be passed. Only then an application can be filed.
Okay.
And I've also given my email ID. So any queries with respect to filing of patent, you feel free to email.
Okay. Thank you, ma'am.
Specific details also.
Okay.
Thank you, ma'am. And now request Dr. Nilakam sir to come forward to share his insights. Sir, over to you. Please unmute yourself, sir. Dr. Nalathambi sir, are you there? Dr. Vendapan sir? Okay. Ma'am, can you just share your
Hello,
experience?
am I audible?
Yes.
Okay. I think I'm quite late to join this event because I was out there for another conference today. I could come only by now. But anyway, I think a lot of useful points have been shared by the advocate madam. Just by hearing by the last one or two questions, I can understand that. Maybe in the next time or after seeing the recording, I'll recording the YouTube. I can come back once again and I can ask the doubts through Dr. Maidvi to the advocate. For the time being, for the time being, I just say congratulations for the event, both for the advocate madam and Dr. Maidvi for conducting this. Thank you.
Thank you.
He's one of my professors. Can you just share your basic experience? I need a basic keynote on before starting patents, ma'am, because I myself think it's a huge task indeed. So in my vision, it's a big deal indeed. So can you just make it simple, ma'am? Because you have elaborated half an hour. But
Can you
brief it,
repeat? I think I missed some part.
For a beginner, what is your advice to make ready for applying for a patent, ma'am? I need the basic things.
Okay, so before you apply for a patent, now say you have a new formulation. That new formulation should not be something which is already there existing, which is say it shouldn't be a traditional medicine which is already available. Especially in Siddha, it is very important that you must analyze what is the innovation or what is the formulation that has been invented, or specifically formulated by you. So first step is to identify what is the new thing that you have come up with. Now, it should not be just adding components. I'm adding so and so compound A, B, C, and D. Now this just admixture of chemical components, you cannot get a patent for it. It should always contain some innovative steps or inventive steps. If it contains inventive steps, then it can go ahead for a patent. Now, once you have made up your mind, or once you have done something, you want to have a medicine for cure of certain particular disease. Let's say for COVID also, you want to invent a formulation which cures COVID. Now, for that, what you need to do is you need to firstly identify what is the particular substance that cures COVID, and you can consider it as the main component, but you need to add certain formulations, because it is not that something you get in nature that cures COVID as such. So the particular formulation needs to be invented by you. Now, once that particular formulation is there, then you can go ahead for filing a patent application. It should not be just it is there, you add something and apply for a patent. It is not the case. You need to make certain new inventive steps. Now, say pulverization. The pulverization is already there, but how are you making it, and what are all the it is not that certain components you're just adding to the existing ones. It is you should convert it into some other form and then add it so that it becomes inventable.
Can you share the cost of that? Means I need that. What will be the cost for filing a patent till it is approved?
Okay, now the cost the cost, both the government and the professional charges will depend on who is the person who is applying for a patent, because different costs are there for individuals, for small enterprises, for institutions, both government cost as well as the professional cost. I can probably do something. I can just share what will be the rough costing to your email ID just after the lecture, so that you can circulate to everybody also. And because it involves a lot of steps, that is why I'm not able to tell it right away. And the rough period for granting of a patent would be approximately 4 years, just after an application is filed.
Okay. How to find out, ma'am? Will we get any mail if it is approved, or we have to check the
Sorry, can you come again?
website? No, ma'am. Should we check the websites, or will it be intimated through the personal mail that it is approved or so?
Okay. Now, after an application is being made, as I said, now if there are certain queries from the registry, they would be they would be getting back to us. It is not that they will be communicating it through the agent who has filed the application. So all the communications to the individual or the small enterprise or the institution will only come through the patent agent from the registry. And it is not that just after we file the application will be scrutinized and a patent will be granted. That is not the case. It has a lot, it has quite got a series of steps to be followed. So only after all the steps are being done, then a patent will be granted, which involves examination, publication in the journal, and opposition, and giving reply for the opposition, and show cause hearing. So after all of this, only a patent will be granted.
Is it like,
Madam, is the 4-year waiting period is also in other countries also, or only in India? Is there any country which gives you a patent in a faster time, maybe 1 or 2 years?
All this filing of patent applications are all country specific. So if you need to, if you require a patent in a particular country, then you will have to file it in each particular country. And other countries, some countries are faster, some countries are slower than us. Now this 4-year period is a tentative timeline, 3 to 4 years. Though they might say that in 18 months you will be granting a patent, that is not the case. And practically, it takes about 3 to 4 years. It can be a little early also, provided there are no objections and no oppositions. Then it can be a little faster. But still, this is the approximate time period. At least 3 years.
Okay, madam, let's take it for granted that I am filing a patent application. And before getting the patent, somebody else start producing the drug, claiming that they have found that, they have invented that. What happens? They start producing that particular drug or that particular machine before I get the patent. What happens in that scenario, madam?
Okay, so firstly, the priority date. So the date of filing of the application will be firstly freeze. So that will be one of the evidence which you will have in your favor. Now, if it is in the transition stage, wherein you have not actually obtained a patent, but you've already applied for a patent, then you of course have legal remedies. You can file a patent infringement. You cannot say it is a patent infringement suit, but you can say that you have a right over the particular invention and go ahead with legal recourse remedies. Because only when when you have a patent granted in your name, you can go ahead with a patent infringement suit and also claim for damages. But this is violation, or this is like copying your stuff. So for that, you can of course go ahead for filing other suits, but it is not a patent infringement suit, but claiming your right, you can go ahead.
Okay, madam, thank you. Point taken, madam. Thank you.
Thank you, ma'am. Thank you for answering. Is it the same procedure followed by we apply for any, means publishing any research article or review article in any journals. So more or less the steps are same or it differs now?
No, regarding publication of journal articles, it is altogether a different one, because publication in journal will be covered under copyright only. That has nothing to do with patents. But say if you have a new write-up, then you can go ahead with registering your article or registering your write-up with the Copyright Office. So any literary work, you write something and diagrams, etc., photographs, everything can be copyrighted.
Ma'am, good evening, ma'am.
Yes, yes.
Yeah, actually, from this question, I have a continuation of the question. Because,
Yes.
for example, I have came with the innovation in one research and it got published. Okay, it was published in 2013. Like that time, I am not aware about patent, all these things. But during the course of knowing the knowledge on patent, I was informed that you can go for patent with this, provided like you should little bit you should either add or a little bit you should modify the thing. So like, because why I am asking this means because that was a research paper that was it was a copyrighted. So it is copyrighted in my name only. Can I go further with the patent? Because it is it is not other work, it is my work only. So how can I take it up further?
Okay, so firstly here I would like to give you a demarcation of what is copyright and what is patent. Now, anything you write in you write as a research article, that is covered under copyright. Now, anything which you have invented, it is in a tangible form, then it is capable of getting a patent for it. Now, this copyright, say you have already published it in a journal. Now, a copyright will automatically arise even though you have not applied for a copyright. But if you have applied for a copyright, it gives you additional protection. So as soon as it is published, a copyright will automatically exist for a period of 60 years from the life of the author. So you always have now say, for example, you've already written something and some other person wants to also write on the same lines. He can of course use this, but he cannot exactly copy it and then use it in his article. But he can take the idea of it, he can reproduce it in his own words and also give a reference to your article which you have already written. So that reference should be given. Only then it is not called plagiarism. Otherwise, it is plagiarism. And though India, it is not very strict in plagiarism laws, other countries are very, very strict in plagiarism laws. And it is, of course, they consider it very serious. It is not that somebody copies from the article, reproduces the same thing and gets an article published. That is not the case. That cannot be done at all. And for getting a patent with respect to this, now say for example, you have already written a research article, you want to develop on that article and you want to have something which is invented through the article, that of course you can go ahead and do it. Provided there is something new added to it.
Okay, ma'am. Okay, ma'am. Thank you, ma'am. Thank you.
So I think in terms of Siddha, we have our own classical foundations, and if we are willing to do something innovative, we can change its dosage form or in terms of its type of making it, and we can register it as a proprietary medicine. So in that way, we can patent our innovations like in IPR filing, I think so.
Okay, now this proprietary medicine is the one that I was talking about, giving the example of Tulsi Tailam. So it is already there and it is also being used by us for centuries. So that cannot be as such patented. But if there is something added to it, and if say Tulsi Tailam is being used for treatment of cancer by adding some other components to it through innovative methods, then yes, that can be patented. Otherwise, as such, tulsi telam cannot be patented. I hope I'm a little clear on this.
Right now, are you dealing with any files related to Siddha system of medicine, ma'am?
As on date, I do not, but we in fact have an application which is in process for being filed. They're in talks.
Okay,
So
madam. Okay, madam. Thank you.
once the formulation is done, then probably we'll go ahead.
Okay, madam. Thank you.
Is there any other means?
Can you be a little louder, ma'am? I'm not able to hear.
Apart from searching or surfing from browser, is there any other means like searching in the IPR website itself to find out whether what are the patents so far done in Siddha field? From our field, we want to search means what is the mode?
Okay, now this Google search that I was telling you is only a preliminary search for your understanding. Now, if you're really serious about the invention, if you already have something in hand, then probably you can approach a patent professional for getting a proper search done. So what a patent professional will do is a proper search is being done on the entire IP database, and a series of results matching this is being given. Now, once the results are being given, then you can analyze whether your formulation is matching or it is already existing or it is a new one. If it is a new one, then you can go ahead with filing the application. But it is always advisable to get the search report before filing the application.
So, and one more, being a citizen of India, can I file file my innovative in other countries' patent website, ma'am?
Yes, you can go ahead and file. We have this WIPO. So from India itself, you can go ahead and file patent applications in other countries. So there are a list of countries under the Madrid Protocol, which are in the in WIPO, so World Intellectual Property Organization. So from India, being the parent country or the parent country under which you will you as an applicant will come under. So if you have already filed an application in India, with this priority application you can file other patent applications in other countries from India itself. So that particular patent application will go to those particular jurisdictions, and if there are any oppositions or objections from that particular country, then we will have to look out for some particular patent agent in that particular jurisdiction for giving suitable replies. Part of it can be done from India, but part of it you have to approach that particular jurisdiction patent professionals.
I have heard that it deals with Intellectual Property Rights Commission, isn't it, ma'am?
Can you be
Patents are dealt with Intellectual Property Rights Commission, isn't it, ma'am?
It is not Intellectual Property Rights Commission, but it is World Intellectual Property Organization, and here we have the Intellectual Property Board in India.
So on filing or after approval of the patent, so is there any honorary provided for that?
Is there any?
Or should we apply for it? Honorarium. I have heard from my seniors that some honorarium is provided for approved patents, ma'am. Is it so? Or should we apply separately for the honorarium?
It should be applied separately, and that is not from the patent office itself. So that is something which is absolutely different from the office. not related to, the patent office or the intellectual property board. So that is from separate individual organizations.
Okay. So can you just elaborate on what is the difference between personal property rights and intellectual, that is IPR, intellectual property rights? What is the main difference, ma'am? Because in personal, we'll be having the, the, what to say, the thing as a property, but regarding patency, we'll have the rights as a soft copy, not in terms of any things in what to say. I'm not sure. I don't know the exact wordings, ma'am. I think you got my point. What I mean to say is, like if we have private house as our own personal property. So what is the difference between having personal property rights and the IPR rights?
Okay. So generally property rights means anything with respect to property that you own or your family owns. You might it can be a self-acquired property that you have earned through your own sources, or it can be an ancestral property which has devolved through your ancestors. So that is all covered under your general property rights. But intellectual property rights is something which is produced as a result of using your intellectual capacity. So if you have used your knowledge and your ability, your skill, and you have reproduced something which is a result of these, then it is called intellectual property, and you have a right over your intellectual property also. So that is called intellectual property rights. I hope it is quite clear now. And any other doubts with respect to this?
Yes, ma'am, of course. Usually,
Now, I just 1 minute. I would also like to add. Now, intellectual property rights will be given for trademarks. So, trademarks is the name, a brand name or a company name will be covered under trademarks. Second one is copyright. So, any literary work, dramatic work, diagram, photograph, drawing, etc., are all copyrights. This will be registered under copyrights. Your journal publications, it can be registered under copyrights. Next one is patent. So, any invention or a new product or a new process can be patented. There's something called design registration. So any design that has been newly formulated, so that can be also registered under the caption of designs. Last one is geographical indications. So geographical indications is something which is, for example, a product from a particular geographical jurisdiction. Now, for example, Assam tea, you get Assam tea only in produced from Assam. So all that is geographical indication. Tirupati laddu, etc. And today also I saw in the news that they want to have this Tanjavur Nadaswaram, protected under the caption of geographical indications. So these are all intellectual property rights.
thank you, ma'am. So, properties are handed over to the next generation, like their siblings or whatsoever. In the same way, can we hand over the IPR also, ma'am?
To some extent, yes. Not completely, but to some extent, yes. A patent is being granted for a period of 20 years. Now, this 20 years period is yours. Now, you have a patent certificate and it is valid for 20 years. Now, in this 20-year period, you can license it to anybody, you can assign it to anybody, you can grant them the right to use it. So you can actually make good money in this 20-year period by assigning it, licensing it, or granting the right to use or reproduce also. You can do that. So just like property, you can also pass it on, pass on your intellectual property to other individuals.
Okay. So thank you, ma'am. But apart from earning money, what are the other benefits, ma'am? Like if it promotes our Indian currency or something like that.
Of course, see, if you want to, and if an innovation is being made, that innovation, how is it being used and for what purpose it is being used? What is the objective of the invention? Is it related to public health? If it is related to health, then yes, your invention has actually helped a lot of people in their health aspects. Or if it is related to, in Siddha, it is mostly related to health only. So I'm just covering on the aspect of health. But in other, other innovations, for say example, a machine is being invented. So this machine is actually making your life easier. So apart from money, it is also contributing, to your time. And if you're able to market your innovation to other countries, you're also making a mark of your country in other countries also. So that is also there.
What are
These
the
are all
other
the value
benefits?
additions. These are all the value additions.
Thank you, ma'am. Any other points which you missed, or in your experience, you might have thought to share to the youngster or toddlers? So we can share now, ma'am. Regarding
Okay, so instead of creating a hurdle or having a question as to whether it is whether I need to get a patent for an innovation, I would always advise everybody to widen up your thoughts, make new innovations, have new inventions, get your product, or work on it, do some research, get your product, and then whether it is being patented or not, it's a secondary question, but at least it will help for the it will be a help or a boost to the society and for other individuals who are working in the particular area. So I know a lot of people who have spent years on making a new product or having a new invention, but some get frustrated and stop in between. But no one should stop in between. You should just continue with your research, even if it takes years to complete. That's still okay. You can go ahead, and at one point of time it will reap good benefits.
Thank you, ma'am.
Ma'am, if uh, we are doing our PG project and submit it in university and college libraries, if anyone publish in journals or they copy our research work in their project, can we do any copyright strike for this regarding, ma'am?
Of course. What you can do is you can firstly send out a legal notice stating that it is your work, and what they have done is a copying or a replication of your work, and ask them for damages. You can sue them for damages.
Okay.
Because once a work is being published, a copyright will automatically exist, even though a particular application has not been filed with the Copyright Office. So as soon as the work is published, a copyright will automatically exist. And nobody has got a right to copy it without your knowledge and consent. And if a reproduction of that work is being done with due reference to the work that you've already published, then yes, it can go ahead. But if a reference has not been done to your work, then you can definitely sue them for damages.
Some things to do as a research work, and we give that result, somebody copy the same thing like that, ma'am, in their dissertations.
That is actually absolutely copying your stuff, and you have a right to definitely sue them.
Okay, ma'am. Thank you.
Thank you, Dr. Rajakumari, ma'am, for coming forward. Any other questions? I request all the participants to come forward if you have any doubts.
இப்போதைக்கு அவ்வளோதாம்மா.
Yes, ma'am. Thank you, ma'am.
And I also see a lot of comments. I individually thank each and everyone for for your comments and your appreciation, and thank you all. In case you have any specific questions later on, even after the session is over, I have given my email ID to Dr. Maithili. You can always contact her and get my email ID, and you can write to me anytime.
Kind attention. Please fill the feedback form so that you can claim your certificates for participating, and also the materials whichever ma'am shares with me, I'll just share in the mail. I think no more questions now. Is there anything to ask with ma'am? Please come forward, unmute yourself. You can even raise your questions in the chat box. It will be answered. I think you have cleared and elaborated everything regarding patency. So no more questions. If they have, they'll definitely approach you, ma'am.
Sure, anytime.
Thank you so much.
So all the very best.
Yes, ma'am. Thank you, ma'am. Thank you so much. I now request Dr. Alamilu to come forward to share her vote of thanks.
Good evening, one and all. Yes, ma'am. Is it audible, ma'am?
It's very clear.
It is audible.
Okay, ma'am. Good evening, one and all. On behalf of Siddha Dedicated Forum, I would like to thank ma'am or Prem Rajakumari ma'am, who is an advocate and intellectual property right consultant. Ma'am explained about patenting of Siddha drug and what is patent, what is the type of patent, criteria in patent drug, procedure for obtaining patent drug, essential of patent drugs in a very clear and elaborative, understandable manner. Thank you very much, ma'am. And clearing the questions in a very simple and understandable manner. Thank you, ma'am. And I would like thank our senior doctors who are all participate in this session. Thank you, one and all. Thank you.
Thank you.